You may proceed.
Thank you. Good afternoon, and may it please the court, Drew Packett from Braverman Greenspun on behalf of defendant appellant, the Board of Managers of the Charleston Condominium. At the heart of this matter is plaintiff's conclusory and erroneous claim that the board and the individual members of the board neglected and refused to address the alleged plumbing issues in plaintiff's unit.
Can we really reach that issue? This is a pleadings motion, right? 3211A1, A7, we must assume for the purposes of the motion dismissed the truth of the allegations, et cetera, et cetera. Why hasn't plaintiff, for example, stated a cause of action for breach of fiduciary duty based on the allegation that she made numerous attempts to resolve the plumbing issue and it wasn't resolved, although you folks seem to believe that it was resolved? Aren't those issues for discovery and ultimately summary judgment and trial?
Certainly. So the breach of fiduciary duty claim is one that has a heightened pleading standard. As part of that standard, a plaintiff must demonstrate or allege specific information concerning that alleged breach. Here, there's no allegation of a complaint that was made that was ignored. Here we have a situation.
She could not bathe in her apartment for 2 years. For 2 years.
Well, Your Honor,
That is more than sufficient, counsel. More than sufficient.
Well, Your Honor, the issue again here is that she never put the board on, which was in late 2019. And again, that's 1 year after residing in the apartment.
So we should ignore in her complaint that she had made complaints prior to that to the building manager or superintendent, et cetera. I forget his name.
Right. So the issue with that is that this building manager was first introduced in her supplemental affidavit that was offered to address the deficiencies in the complaint. There is nowhere that is mentioned in the complaint about this resident manager or the—
Counsel, we're allowed to consider an affidavit to amplify what's said in the complaint, correct?
Correct. However, and this court has done in the past, and I recited to in our brief, Lebetron v. Weiss, this court can disregard an affidavit that directly contradicts what was alleged in the complaint. And in the complaint—
It doesn't contradict it. I think the affidavit amplifies. So if we disagree with you that it doesn't conflict but amplifies, then you lose?
No, Your Honor, because again, the affidavit in the complaint, plaintiff alleges that the first time she put the defendant on notice was when she reached out to Douglas Elliman, who was the condominium's property manager, managing agent at the time. Okay? And she says during that year, she sent countless emails, countless voicemails, countless communications. However, in her affidavit, she admits that she did not reach out to Douglas Elliman until late 2019.
Wasn't there allegations that she reached out to a Mr. Arafi who told her not to lodge any complaints because he was going to take care of it? I mean, why isn't that allegation enough?
So again, this is something outside the scope and something that
Outside of the scope of what?
Complaint. So in the complaint, again, she says that the first time she put us on notice was when she reached out to Douglas.
Counsel, I understand you saying that, but as my colleagues have pointed out to you, case law is clear that we can consider an affidavit. And in this instance, isn't her affidavit simply supplementing what the complaint says with respect to the issues, the complaints, and really the inaction of the board?
Respectfully, I don't think that it does. I think what it does is it tries to cover up, I don't know if, I guess cover up.
That's an interesting use of words on your part.
Cover up her failure to reach out prior to, or in a time where the board had a meaningful chance to respond. Again, you have a situation here.
But incidentally, the complaint also says that back, I think starting in 2014, the building was on notice through Culligan that there was a problem with the water. There was a report out there. So it's not as if, according to the complaint, which for the purposes of the motion we take to be true, the board was already on notice of the problem.
Well, there's no mention in the complaint about anything with respect to what that report said or what it did. The only report—
You're not aware of a report? Is that made up or what?
There was no, when pressed on our motion to dismiss, she didn't, despite claiming sufficient knowledge of what that report stated, it was not provided.
Well, the report was issued 4 years before she took occupancy. So
Correct.
it is your clients who are in the best position to know what that report says, since it was your clients who had it done.
Well, again, the report also, there's no mention from the plaintiff, if that report even is involving or discussing her unit. It has nothing to do with her allegations that were made in the complaint or.
The report talks about contaminated water, correct?
That's the 2020 report. There's a 2020 report that is annexed.
I'm not talking about the 2020 report. I'm talking about the 2014 report that my colleague addressed earlier.
Yeah, there's been no indication what that 2014 report says. It predated her involvement. There's no mention that that report.
And again, only your clients would have that information, right? Because I would imagine it's the board who had that report generated.
I can't speak for the
You
report.
are not suggesting that a company was allowed to enter your building without the authority of your board, conduct tests of your system without your board knowing about it. You're not really making that argument here,
No,
are you,
what I'm making,
counsel?
the argument that I am making is that there is no demonstration of what this report actually says. There's nothing that says that the other unit owners in the building have been complaining.
Is that required?
No, Your Honor, it
Okay,
is not.
so then that's irrelevant. All that matters is that the water coming out of her faucet is toxic.
So
It has chemicals that she cannot bathe in.
So
The water smells, it's green or brown, depending on how long you run it.
Well,
That's what the record shows.
the report does not indicate that the water is toxic. The only positive finding in the report is that there is mild turbidity. Turbidity is cloudiness. And again, that report, the 2020 report that says about that mentions turbidity was generated once plaintiff notified the board of the issue. She notified the board of the issue in late 2019. That report is generated weeks later. And then remedial work, $15,000 of remedial work was performed at in order to address the issues in her apartment.
And it didn't resolve it.
Well, after that, there have been no further complaints from Ms. Rosenthal about the conditions in her unit.
Well, apparently, we're still here. So there's obviously an issue, right?
Right, and again, I want to just get, this is a pleading issue, and it is that that the plaintiff did not satisfy their pleading requirement to avoid a motion to dismiss.
Thank you.
Thank you.
All right.
Afternoon, Your
proceed.
Honors. Jeffrey Metz for Respondent. Your Honors, if the bench has no questions, I'll rest on my brief.
Counsel, were there complaints made after New York Plumbing was brought in to remediate the problem?
As a matter of fact, they were, Your Honor, in April of 20. And if you go to page 252 of the record, you still see the green water in the bathtub. My friend over here has made several misrepresentations to the court that maybe I should clean up. As the bench pointed out, from when she first came in October of 2018, she had a problem. She dealt with the resident manager of the building who essentially gave her a runaround for a year and then said, I can't fix it. She then reached out to Douglas Elliman. Now, Douglas Elliman made very half-hearted and ineffective efforts to resolve this situation, which, by the way, existed at the time the complaint was made and still exists to this day. It has not been fixed. It has not been fixed. There is a fiduciary duty on the part of the board to fulfill statutory authority, housing maintenance code, multiple dwelling law, also, in addition, the condominium documents. It's their responsibility.
Counsel, is your client the only one complaining about the water condition, or is it your claim that it's building-wide?
I didn't say, no, we're not claiming
it's just in her
that
line?
it's building-wide.
You're saying it's in her line only?
It's in her, well, her line, by the way, Your Honor, is the only line that has the bathtubs, the K line.
That has the what?
Has the bathtubs. It's the only line that has the bathtubs. So this may not affect others. And the half-hearted remedial work that they did was dealing with the plumbing pipes to the master line into her apartment. And whatever they did or did not do, it certainly did not work. And you can see in the record, and I find it almost incredible that my colleague would say that they were not put on notice of it. As you pointed out, Your Honor, way back, even before we even came in 2014, there was a Culligan test, said there was a problem with this. They were put on notice, they did nothing. We put them on notice in 18 for a year. They did nothing. Then finally,
Was there a formal, so she dealt with the gentleman who was the building manager,
right, the resident manager.
And was there a specific manner in which complaints had to be filed in this building? Was it just a phone call to
Well,
this gentleman, or was it some kind of form that had to be filled out?
It's interesting that you say that, Your Honor, because according to the client's affidavit, there is some building line, there's some sort of site that you can put in and notify everybody in the building. And he said, don't put it in there. Don't put it in there. I'll take care of this. So he led her down the primrose path for a year before Douglas Elliman got involved. Now, this, I tell you, this is not complicated stuff.
Does this gentleman still work at that building?
I don't know that. Maybe my colleague knows that. I do not.
So you haven't been able to speak with him or get an affidavit or depose him or anything like
Well,
that?
Your Honor, we filed a complaint. They moved to dismiss. And it was denied. They put in an answer. And by the way, I mean, this complaint, I mean, let's just go back to, you know, to take my colleague's argument to the full extent would be to reverse decades of settled authority with respect to motions to dismiss. You have to give me the benefit of every inference. Whatever I say is true. If it states any cognizable cause of action, you must find it there. And if there's any defect, and by the way, there aren't any defects in the complaint, it was more than adequately made up by her detailed affidavit. So I would ask you to affirm. Thank you very much.
Thank you. You may proceed.
Thank you. And just one quick thing first, I just wanted to mention another that I didn't get to touch on initially, which was that in addition, the lower court erred because it failed to dismiss each of the causes of action against the individual board defendants. There have been no allegations in the complaint or in the affidavit that address any conduct by the individual board members. Now, going real back to the complaints following the post remediation work. My colleague here cited to April 20th. The unit owner, she was not living in the unit at that time. What happened is that in February—
This was during COVID.
COVID, yes.
That she goes to live with her mother because she can't bathe in her apartment.
Well, I'm not sure I agree
sorry.
with that. But so the thing here is that, again, when the board was put on notice, they did the work in February. Then, after February, she moved out. Then, in April, when they received, it wasn't even a complaint, it was follow-ups from the attorney asking for an update. The attorney was notified. We performed remedial work in the apartment, okay? When she returns, she may experience brief bouts of sediment buildup due to inactivity. However, that will be normal after 5 or so seconds, whatever it is, 1 or 2 minutes, and that things will proceed as normal. From that moment, when she returned to the unit, till I guess a letter sent by the attorney a year later, there was not a single complaint to the board. As a result, the board was under the impression, well, the issue was addressed. The board responded to the attorney letter and said, look, if you're having issues, please let us know. Contact the managing agent, contact the super, let us know, we will handle it. What happened? Nothing for several more months, and then this action was commenced. If the panel has no other questions, I rest on my papers. Thank you.
Thank you. Have a good day, gentlemen. Sibley's versus City of New York.